Yes, Ms. Hitching.
My Lord, before the short adjournment, I was just wrapping up what your Lordship described as the wee point. Might I remind your Lordships of what Mr. Pleener said in opening? And I understand your Lordships will be provided with a transcript to review. So for your Lordship's notebooks, it was a submission made at 11:16 this morning, when he said, if the dropping of the bomb was either a concurrent or the proximate cause, I lose. Exeter has not appealed against the finding that the dropping of the bomb was a concurrent proximate cause, and therefore he loses on each of grounds 1 to 3 and 4.
I take it you're not going to sit down now.
My Lord, I was tempted at that point to take the invitation to be the brave advocate, but no, I'm not going to, because your Lordships, having heard submissions from a learned friend, will be considering them with care. And I hope to persuade your Lordship that he is also wrong in challenging the finding of the learned judge below that the bomb was the proximate cause, albeit I don't need to. That was my first topic. My second topic is the agreed facts, and those are addressed in paragraphs 3, 9 to 10, and 11 to 12 of my skeleton argument. I want simply, in oral submissions, to draw out a few points.
Yes.
Turning to my skeleton argument, paragraph 10. At B, I note that my learned friend is seeking to revive a passage that appeared in his written submissions before the trial below. There is no good reason for him to do so and to revive a phrase that it seems likely that the bomb was dropped in the Second World War, given that he agrees that as a fact and indeed had done by the time of closing submissions. It appears, having tracked this through, that certain passages of this skeleton argument on appeal were simply cut and pasted, albeit in a slightly different order, from the trial skeleton. And in fact, they were overtaken by events, overtaken by my learned friend's oral submissions at trial. We see the same in the passage that I've dealt with at paragraph 10c, where again, in my learned friend's skeleton argument, he tries to make something of the fact that the reason for the bomb being moved was unclear and there was no evidence on it at trial. Now that's wrong, and he accepted it was wrong in oral submissions at trial. The MOD report, which I've quoted from at paragraph 10c, explains why the bomb was moved. He accepted that at trial and withdrew that submission. It's concerning to see these points revived. It may simply be a series of mistakes made at speed cut and pasting, but we are concerned that they are raised in order to give a general impression that the learned judge did not properly grapple with the case, and that this court should somehow be concerned that there was inadequate factual evidence at trial. If so, that impression is wholly incorrect. But it goes further than that. I address at paragraph 10e of my skeleton argument a point that has kept rearing its head, albeit in slightly different form, first in correspondence, then in written submissions at trial, then in oral submissions at trial, each in a slightly transmuted form, and now again on appeal. And it is this: a statement as to what the market would or wouldn't understand and what the market would or wouldn't want
Sorry, this is your 10D.
This is my paragraph 10E, my
E,
lord.
I'm sorry, E for echo.
And in its latest iteration, it is being run as a point about what would the market want this policy to cover. That point has never been pleaded. Indeed, Exeter's never put in a pleading. Exeter chose not to adduce any evidence as to market intention at trial. The way my learned friend raised that point this morning was that that rather worked against me. It doesn't. We don't need to adduce evidence of market intention. We say that the wording is clear, proximate clause, that's all what we rely on. My learned friend's solicitors in correspondence initially said market intention was important and they intended to adduce underwriting evidence. They never did. And your lordship should be very wary about a point being run on appeal which was never pleaded, no evidence, and was not in fact run in precisely the same way before the learned judge below.
Arguably, it would be irrelevant and inadmissible anyway.
Indeed. Which was the point we raised in correspondence.
What matters is what the clause means as a matter of standard contractual interpretation.
Absolutely. And on that, my lord, we are agreed. And that's the end of the interpretation point.
You say occasioned by equals proximate cause, meaning either the cause or a cause, and that's the end of the.
That's the end of it. And indeed, my learned friend agrees that. What we then go on to is not the interpretation of the clause, but the application of the clause. And what the market intention may or may not be, which is neither pleaded nor evidenced, does not assist the court on that second issue, that of application.
That's the occasioned by point, and I completely understand that. What about war?
There is no evidence that your lordship requires as to the market understanding of war. Again, that's a matter for interpretation
But
based on the objective intention. There is an agreement that the dropping of the bomb was an act of war, of itself would engage the war clause. So is either an act of war or constitutes war. And the issue is whether it is proximately causative of the damage. And I stress there, picking up a phrase that my Lord Justice Snowden used earlier, we are looking for the proximate cause of the damage, not the proximate cause of the detonation. And here, my learned friend agrees that the only issue for the judge was whether the dropping of the bomb was proximately causative, not whether it constituted war or act of war. So there is, with respect to my lord, no point of interpretation on the meaning of war or act of war that actually arises on this appeal.
Right. Can I see the agreement in relation to war? I completely understand occasioned by the or a proximate cause. Got no issue with that at all. Since the authorities say you should start with the interpretation, I'd be quite interested to see the agreement in relation to war.
My lord, the best place I can take your lordship to is paragraphs 3 and 4 of my skeleton argument for this appeal, because my learned friend has helpfully indicated that he agrees those correctly set out the issues that are and aren't between us. That's the only place I can take your lordship to, given that we had no responsive pleading in this case.
So it's 3B.
The dropping of the bomb was an act of war. That has been agreed. Whether it therefore constituted in the alternative war, I didn't need to satisfy the judge below of. That wasn't a point that my learned friend took against me. And given his oral submissions, it's not a point that he's taking against me on appeal. And it certainly wasn't trailed in his written submissions. So here, all points on interpretation have been agreed, and there is no point on interpretation that is actually live for this court. It's purely a question of applying the agreed law to the agreed facts and bringing it back to the actual grounds of appeal, whether grounds 1 to 3, the judge did so by forgetting the test he just set out and applying another test, or ground 4, reaching a decision that no reasonable judge could have done.
Just 2 points of intervention there, if I may. Although you say there's no sort of interpretation question, I mean, the very question of proximate cause is said in some of the authorities to be derived from giving effect to the intention of the contracting parties. So I'm assuming you're not saying that's ruled out. I mean, that's the very thing we are debating. So to the extent giving effect to the words of the contract is wrapped up in the concept of proximate cause.
Well, Lord, indeed.
It's in play.
The overall issue, the overarching issue is, does this clause bite?
Yeah. So
I'm being forensic, breaking it
you're just
down
saying
into
no-
interpretation and application.
Okay. The second point was, and you may have the advantage of me here, is that I think you said that a moment or two ago, you said I'd drawn a distinction between the proximate cause of the damage and the proximate cause of the detonation. I may have said something like that. I thought that the distinction I'd drawn was the difference between the proximate cause of the damage, which everybody accepts was due to the detonation, and the proximate cause of the propensity, I think as it was put by Mr. Plena, which is really, I think, not what's probably at issue here.
I don't think that the court need to be concerned with the proximate cause of any propensity to do anything or not. It's a straightforward test looking at the proximate cause of the damage.
Yes, I wasn't drawing a distinction, I think, between the proximate cause of the damage and the proximate cause of the detonation, because as I understand it, the detonation is the cause everybody accepts. The damage was the result of caused by the detonation. It's the same thing.
Yes, but that isn't accepting that the controlled detonation was necessarily the proximate cause, because that would be falling into the trap of looking at the last event in the chain of causation.
No, I'm not.
No. I just wanted to make where we stand clear.
Yeah.
Going back to your lordship's point as to, well, does intention come in here somewhere? It does, but only to a very limited extent, given that the parties have agreed that this clause says occasioned by, and that means proximate cause. There is no submission and no pleading that intention could be looked at to imply a term, to imply a limitation on what is agreed by my learned friend to be a test with no temporal bright line. Where intention comes in is really in an appeal by him to common sense. And that's the way we can see it being brought in Arch, paragraph 168.
When you say intention, you obviously don't mean subjective intention, which is why a whole raft of people coming and saying what they think the market understands by X, Y, or Z is irrelevant. You mean it in the objective interpretation of contract sense, do you?
Exactly, exactly. And the point becomes rather circular for my learned friend, because if I can take the points in this order. First, he accepts that the proximate cause test does not contain any absolute temporal cutoff for damage caused by bombs dropped in the Second World War. He accepts that. Dealing head on with concerns that the court may have, is that a problem for me? No. Firstly, it's not a problem for me because Mr. Plena accepts that that is correct as a matter of law. Exeter initially ran a whole number of arguments in correspondence and then at trial, as I've noted in my skeleton argument at paragraph 4, that there was a temporal cut-off at some date. By oral submissions at trial, Exeter abandoned all those arguments. A Maloney friend on appeal has confirmed that he accepts there is no absolute temporal cut-off. So that is not a point against me, it's simply a statement of the law, which Maloney friend agrees to be correct. This appeal concerns this particular clause, which Maloney friend accepts provides no temporal cut-off, therefore. And that's what the parties objectively are taken to have agreed. It may be, and I'm not giving evidence here, it may be that other parties negotiating in the market agree different cover. They are free to do so. They may specifically include a temporal cut-off if they wish, either by amending the War Exclusion or by writing back in an exception. And that's because parties can obviously agree to modify the general proximate cause rule to write in a temporal cut-off. But the parties here have not done so.
I mean, the fact that there's no bright line or cut-off, as you put it, doesn't provide an answer, does it? Because if you'd have said, if you'd asked the reasonable bystander, reasonable observer, contracting parties, a question 1 year after the end of a war, you might get a very different answer to the objective reasonable bystander in the position of the parties 80 years after the end of a war. I mean, so that the fact there's no bright line cut-off doesn't necessarily provide you. You're just, I think, just at the moment
setting things out.
The number of windmills up there that you're knocking over, but they don't necessarily answer the question.
So my first point was, it's agreed that the proximate cause test doesn't have a bright line. That's not a problem for me. That's just the starting point. The second point is, well, can a temporal cut-off be introduced by saying that's what the parties intended, which I think is the point your lordship was moving on to. With respect, no. Because by using the term occasioned by, the parties are taken objectively to have intended that the proximate cause test applies. And that test, as I've just explained, and is agreed, does not have a temporal cut-off. So it can't, a temporal cut-off cannot be introduced by the back door by saying, well, that must be what the parties intended, because they're objectively taken to have intended a proximate cause test with no such temporal cut-off.
I think the whole notion of intention of the parties is a thoroughly dangerous one, frankly. I always prefer to ask, what does the contract mean?
And, my lord, if we approach the question in that way, what does it mean? Occasioned by, FCA and Arch tells us it means proximate cause test.
Yeah.
And that is agreed.
That. It's war.
My lord, yes.
Does it mean a war that ended 79 years ago? And you say that's not a matter for us because of the agreement between the parties, as I understand it.
My Lord, yes, because, but if I take your Lordship back to the wording of the clause, because I don't want that to be read as me being defensive, that we could not satisfy your Lordship on the interpretation point. The clause refers to war or act of war, and the dropping of the bomb was an admitted act of war. So what your Lordship is exploring is whether under the term war, we can import a temporal cut-off so that the act or the damage has to happen during the course of the war. That is as I understand it. But my Lord, if I haven't fully grasped your Lordship's point, please do clarify.
Well, if I was coming to this clause, I would say that doesn't include the Second World War, just as a matter of common sense. How can it? The Second World War finished 80 years ago.
Indeed. So your Lordship's point is that within, when reading the term war or act of war, one reads into it
Actually,
ongoing.
the words act of war don't appear there. It's the act of a foreign enemy. It's war or act of foreign enemy, but it's not act of war. Is it? Am I reading the wrong clause?
No, your Lordship isn't. What's been agreed here is that because the dropping of the bomb was an act of war, it engages the wording war. And that was what my learned friend explained earlier when he was referring to the passage.
So the answer to my earlier question is yes, because of the agreement between the parties, you say it's not open to us to offer a view about what is meant by war.
Lord, with respect, yes.
And I suppose you would also say that when the bomb was dropped, it was an act of foreign enemy.
Indeed, and was during the currency of the war. So there's absolutely no doubt that the dropping of the bomb was war. The issue is rather, is there a temporal cut-off when one's looking at proximal cause because the damage happens afterwards?
Issues just if we weren't hemmed in, as you have it, by the agreement between the parties, the issue is what does the, as my Lord puts it, what does the contract mean?
Lord, yes. And it's
So-
no discourtesy if I say to the court that the court is, as on any appeal, hemmed in by the points that were
I
run below.
understand. No.
And indeed on appeal.
I completely understand that, Ms. Hitching. I'm just trying to work out what the limits are of any room for manoeuvre. And on your case,
Not a lot.
none. No, I completely understand that. It's just feeling where the boundaries are.
So my third point is, well, could the temporal cut-off point nonetheless be introduced by the common sense route? Does that give, is that the route that gives the court some wriggle room? Well, again, no.
And by cut-off, do you mean a bright line cut-off? Or do you just mean time is irrelevant?
Time is not irrelevant, but time is merely a factor to be taken into account when applying the proximate cause
But I
test.
didn't understand Mr. Plena to be arguing for a bright line cut-off.
No, he's not.
So why are we having this debate?
Because although he's not arguing for a bright line cut-off, the point that he keeps coming back to is the war's a long time ago.
Yeah, but that's a time point, not a bright line cut-off point.
No, and I'm not disagreeing with him on that. But it is important to explore, therefore, what the significance of the passage of time is. And here, it's not the fact that time passes that the court is concerned with. It's what is the significance of the passage of time. And the difficulty, the fundamental difficulty that my learned friend has is that the passage of time has actually had no significance.
Has what?
Has had no significance. And this is where the learned judge explains that the passage of time has rendered the bomb no less lethal.
But I think Mr. Plina says the passage of time does have a significance because it has allowed for the establishment of a status quo. And the bomb may be no less potent, but it's also not likely to go off either unless something else happens. And that's what Mr. Plina says was the proximate cause, namely there's something else.
But as your lordship put in discussion earlier, whether something is or isn't a status quo is really the reverse of the issue. So simply saying it's a status quo doesn't take learned friend's submissions any further, because what the court needs to inquire for determining is it simply a status quo or is it proximately causative is what's its effect. And my learned friend comes back to the fact that it's not just the controlled detonation, it's the fact that it's the controlled detonation of a bomb that was dropped that is still lethal. And simply saying, well, that's a status quo, is rather like the argument that the owners of the torpedoed vessel unsuccessfully ran to say, well, we may have a situation, but we then look at what's really caused the loss, and that's the ingress of the water.
But I think the distinction that's put against you there is that there was actual active damage at that stage in relation to the ships, whereas here there's just nothing.
That point certainly is put against me, but in response, I would refer your lordship to Arch, which has confirmed that the principles laid down in both the Reicher and Warwick case and Leyland are of general application and set out the proximate cause test. They are not cases limited to where there is initial damage and subsequent damage, and the court should be very concerned about placing too much emphasis on the facts of those cases. That may be a useful point to turn from the agreed facts and to take your lordship briefly to the agreed law. Learned friend has taken you thoroughly through the authorities. There are just a few points that I want to draw out. And this is paragraphs 13 and 14 of my skeleton argument.
Just on the agreed facts before you do, Mr. Plina was very keen to urge on us a number of occasions that there was no evidence that before the judge that suggested that the bomb was likely to go off of its own accord, it not having done so for 79, 80 years. I think that's right.
There was no evidence adduced by either party at trial, but as I'll come on to, that's actually irrelevant when I look at the agreed law. That's actually irrelevant because it's looking at the question of causation and inevitability from the wrong angle.
I was just dealing with it in your agreed facts section.
I apologise if I cut your lordship off.
No. I didn't want you to go herring off to something that I wasn't interested in.
But your lordship has rightly reminded me of another point that the learned friend made under the topic of agreed facts that I do want to address, because this was a point that I haven't found in his submissions below, or indeed in his written submissions. At 1046, he said, had the ACE not been out of action, it would have successfully steamed out the fuse. That is not pleaded. There is absolutely no evidence of that. First, there is no evidence that the ACE, even if available, would in fact have been used. That would have been the choice in the expert opinion of the EOD.
Well, I think the incident report said that it would have taken 4 days and it was going to be too long with COVID.
Indeed. But even if it had been used, and we're getting into multiple counterfactuals, which is really a very dangerous course, even if it had been used, there is absolutely no evidence as to whether it would have been successful or not.
Well,
this was a technique.
yeah, it would seem pretty unlikely. I mean, I have to say, I mean, I know everybody was really panicking about COVID, etc., etc., etc. But if you have a slam dunk, absolutely surefire technique to defuse a one-ton bomb, then you would have thought somebody might think that's worth investigating a little more.
Indeed.
But there we go.
Indeed.
Anyway, so there's just no evidence either way.
There's no evidence either way, and therefore, when my learned friend is saying, well, the dropping of the bomb's not a proximate cause because a lot of other things happen, COVID happens, ACE isn't available, and had it been, it would have successfully steamed out the fuse. There's no evidence of that. Your Lordships can place no weight on that submission. And as I said, should also be careful because we are not looking at hypothetical counterfactuals. Arch warns us against that. But we're also looking not at what happened at the time the bomb was dropped and looking forward to see if it was a proximate cause and then somehow ceases to be. What we're looking at is, at trial, the damage having happened, let's look backwards and identify what the proximate cause was. And so for that reason as well, what might or might not have happened with COVID or ACE, not relevant. So I keep promising to turn to the agreed law. Perhaps I can turn to that now. I commend the whole of my skeleton on that, paragraphs 4, 13 and 14 to your Lordships, and simply make some oral supplemental submissions drawing some points out. The first, which is at my skeleton, paragraph 4, footnote 4, is that there was a slightly odd argument raised by Exeter that it was necessary, even though it was agreed that the dropping of the bomb was an act of war, it was argued by Exeter that it was also necessary for the controlled detonation to be an act of war. That's now abandoned. My skeleton, paragraph 14a, I wanted to stress that here we're listing synonyms. My learned friend accepts they are synonyms. All those terms, not just efficient and agency of change, which my learned friend particularly lays stress on, are synonyms for proximate cause. And at 1125, my learned friend said, well, agency of change is the most useful here. They're all synonyms, and the court shouldn't be approaching this on the basis that one is more useful than the other.
What about the phrase that you quote in your 14a, made the loss inevitable in the ordinary
Indeed.
course of events?
Inevitability. Inevitability, and I touch on that at 14g, my lord. The question of whether an earlier cause made the loss inevitable in the ordinary course of events is to be examined on the basis of the facts known at trial, which is agreed to be a correct statement. That's more than saying the court is purely looking at all the facts which are available. It's because inevitability is this backwards-looking assessment rather than a forwards-looking assessment. One doesn't start with the dropping of the bomb and say, was it a proximate cause of something in the abstract? And does it continue to be a proximate cause? One starts with the damage and looks backwards to see what proximately caused that damage. And that's where inevitability needs to be understood. It's not inevitability assessed from the time that a torpedo hit or the bomb was dropped. It's inevitability in the sense that we can, with hindsight, trace through the inevitable cause of events.
So does the reasoning go something like this? We've got damaged buildings. We ask what caused the damage to the buildings. Answer, the bomb detonated. Why did the bomb detonate? Because there was a controlled explosion. Why was there a controlled explosion? Because we couldn't possibly leave the bomb, having found it, without blowing it up.
Indeed. Without, however, falling into the trap, my lord, of me appearing to suggest either that it's a but-for test or that the existence of the bomb was a state of affairs.
But you have to, on this inevitability point, you do have to say that for you to succeed, you must show that the thing which is excluded by your policy, i.e. war, inevitably caused the damage which would otherwise be covered.
Yes, we accept that. That's part of the proximate cause test. But inevitability is only a synonym for the proximate cause test. It's not a substitute. It doesn't somehow make the proximate cause test harder. And perhaps I can illustrate that best by asking your lordship.
So just to pause, just so I've got it. So it only, is this right? You only get an inevitability argument off the ground when the houses are built. Why is it inevitable? I mean,
one's only looking. It's not a question of getting an inevitability argument. One's only going to be looking at damage to something that's been built.
yes.
That's the reason.
So asking, as the judge appears to have done at a number of occasions, whether when the bomb was dropped, was it inevitable that the damage would be caused, is not actually a very helpful question.
In context, that's not how we read what the judge was actually doing. What the judge was doing in a very short, structured section of the judgment, which even highlights the structure by the head notes, is working through what the significance of the different facts are that then go into the mix, that come to the overall common sense conclusion. We don't read this as the judge assessing inevitability from the point that the bomb is dropped. That's not what the judge is doing.
And maybe the point is that one of the authorities, the old one, I think, says it's nothing to do with a chain, but it's a net.
It's a net.
Lord Shaw, I think. You'd say that this is a good illustration of that.
Certainly the judge did. And that's what he said. He said causation is a net, not a chain. And then he went on to apply that test. If I can come back to inevitability, because I think, my lord, it will help to see the application of this principle in the context of the facts in the leading case, which is Leyland. Maloney Friend placed considerable reliance on this case and at 11:59 said, there is no doubt that from the time of the torpedoing, the ship would have sunk. Now, with respect to Maloney Friend, and I appreciate he was on his feet at the time, that is completely wrong. If I could ask your lordships to turn to the Leyland case.
I thought the facts didn't matter.
On this point, it will assist your lordship, I'm sure. It will assist with understanding the meaning of the inevitability test, my lord. If we look, and
The case doesn't set out an inevitability test.
no,
That comes from Arch.
we can see that comes from Arch,
Yeah.
but Arch is approving the proximate cause test as set out in Leyland.
Yeah.
And this one point that I want to take your lordship to appears, and I'm going to work from the report numbers, which are on the top left, page 356, my lord. And it's just over a third of the way down. This is in the judgment of the Lord Chancellor, Lord Findlay. and it's quoting from the first instance judgment, which are the findings on the facts.
Yes.
Here you have a torpedoed ship which makes for harbour. She finds a berth where she might be saved if she could stay there. She cannot stay there. She has to move on again. And then we set out what happens as a result of that. But if we pause there, if asked at the point that the ship was torpedoed, is it inevitable that this ship will sink? No.
So that was Mr. Justice Rolat's view.
Indeed. And that is a view that we can see at the bottom of page 42, the final paragraph, where the Lord Chancellor says, I agree with Mr. Justice Rolat.
He having said at page 355, she was not lost by any new peril, but by the natural consequences of the explosion of the torpedo.
Exactly.
I've written inevitable by that.
Exactly. And that's because when one's looking at inevitability, one is looking at it with hindsight. The question isn't, at the point the ship is torpedoed, is it inevitable that she will become a total loss? That's not the question. The question is, her having become a total loss, can the act of torpedoing be seen as the proximate cause, and as your lordship has noted from Arch, the synonym inevitability? That's the way it works. And we can see this on the facts. And the same arguments were run unsuccessfully by the ship's owners in Leyland as are run by my learned friend here. They said in that case, no, it's not the torpedoing that's the cause of the loss. It's what happens subsequently. It's the ingress of the water. And the House of Lords in that case is saying, no, that's not the correct analysis. Yes, things happen subsequently, and it may indeed have been on a hypothetical counterfactual that had the ship remained in harbour, she wouldn't have been a total loss.
I mean, the high watermark of the way Mr. Plina put it, I think, was to look at what Lord Dunedin said at page 364, page 49, where he said, after the Peter struck her, she was a doomed ship. But the rest of the sentence is, unless she could get into a real place of safety. So you say it's not inevitable.
Exactly.
Doomed unless.
Well, one's looking at inevitability. It's to do with the standpoint from which one assesses inevitability, my lord. And it's quite clear here that they are looking at inevitability, the synonym as Arch tells us for proximate cause, but they do so at a point where the ship has sunk. Lord Dunedin is not saying from the point of the torpedoing there was never factually any doubt that she would sink. What he's saying is applying the proximate cause test, inevitability is satisfied. So it's simply not necessary, or rather I should phrase this, reminding myself that we're before your lordship's on appeal, it wasn't necessary for me to prove below that from the point of the dropping of the bomb, it was inevitable that it would explode in the circumstances that it did and destroy the buildings or damage the buildings that it did. That's not the test that we see in Leyland. And on this, your lordships can draw some comfort, and I put it no higher than that, and I put it no higher than that below, from the facts of the Nassau Bay case. And that's in our bundle in our slimmed down bundle behind tab 2.
Is this the one about dumping ammunition?
It is, my lord. Now, we quite accept, and both parties put this before the court below, accepting that this is not a case directly about insurance coverage, but it is of assistance because the usual meaning of war risks under insurance was directly before the court. If I can explain, looking at the head note, it's probably the quickest place to find the facts. The dredger had been lost. I apologise, my lord. It's in the slim bundle behind tab 2, if that helps.
Yes.
The dredger had been lost. This was not an insurance claim. The owners, it seems, we only have a short sentence to that effect, had recovered insurance monies. No significance should be placed on that. We don't know what the terms of the policy were or its exclusions, if any. The issue arose as to whether the monies were paid because of a loss of a ship due to a war risk. Because if they were, then Her Majesty's Inspector of Taxes was keen to raise a balancing charge. And war risks in that context of the Capital Allowances Act was defined by reference to the ordinary English policy of marine insurance. And as your lordships are aware from the other authorities we've taken, your lordships to, those ordinary policies import the proximate cause test. Learned friend is right that the issue before the court in that case was twofold. Firstly, why were the shells there? Who'd dumped them? And that, before the commissioners, had been found to be the Allied forces rather than the enemy forces. There was an appeal against that finding, and your lordship can see at page 403, column 2, how Mr. Justice Walton, dealing with the matter on appeal, dealt with it. I apologise, 403, column 1, the second paragraph down. I have found this an exceptionally difficult matter to decide. But then in the passage, which is double sidelined by us and by the learned editors, on the whole, with grave hesitation, I've come to the conclusion that it would not be right for me, in effect, to overturn the finding at first instance. So we have at that point an undisturbed finding that the shells were there because dumped by the Allied forces. So the next question is, if the dumping was by the Allied forces, was it an act of war? And we can see that at page 405, and this is from the second substantive paragraph down, I conclude that while it is possible for the dumping of ammunition to be a warlike operation, it wasn't open to them to reach that conclusion on the facts of this case.
Sorry, were you 404?
I apologise, 405.
405.
405, left-hand
Yes.
column. The loss was therefore not a war risk for the purposes of the Act. Therefore, the revenue couldn't raise their balancing charge. Now, Maloney Friend submitted that causation wasn't an issue. It wasn't on appeal, but it had been at first instance. And we can see that at page 402, column 2. In the,
Did I get that right? The revenue can raise the charge. Is this right? Unless it's due to a war risk.
my lord, it's the other way round. If the monies that came to them for the total loss of the vessel were due to a war risk, then a balancing charge could be raised.
But if it was not a war risk, they weren't entitled to.
Indeed.
Well, okay, sorry. I'm just going to read section 33 of the Act again.
I think you make the deduction when you lose the ship. When you get the money in from insurers, a balancing charge arises unless the money is paid in respect of a war risk.
Lord, yes.
Broadly speaking, that's how it works.
That's what I thought. Yeah.
Lord, I think we're in agreement. I apologise if I said not and have muddled the court. I was touching on causation. If we look at page 402, the second column, and this is the second substantive paragraph down, beginning, of course. The first question which must be answered is what caused the damages? What caused the damage? And it was found as a matter of fact to have been caused by the dumped ammunition rather than any other fault or failure. And there was no challenge to any of those findings, no appeal. I raise that because the issue in that case, as in this case, on causation, would have been what was the proximate cause, because it was a marine risks standard policy that was the underlying test. And there was no, and I don't want to press this further than I can, but your lordships may take some comfort from the fact that many decades had passed since the dumping of the ammunition. The ammunition was lying safely, insofar as these things can, at the bottom of the sea. The ship was certainly not floating above the ammunition at the point it was dumped, nor for many decades thereafter. And your lordships can see the analogy that I draw with this case. So your lordships can take some comfort from the fact that a tribunal has found the proximate causation test to be satisfied many decades after a war, and in respect of ordnance lying in situ where the damaged property came near it some decades later. Not on all fours, but the court may take some comfort from it.
What's the finding that we can take comfort from? It was not a warlike operation.
No, my lord. On the causation point, page 402, the second right-hand column, that there was no dispute on appeal in that case.
It was caused by an explosion.
My lord, no, that the proximate cause was the dumping of the ammunition. The only issue was whether that dumping was a warlike act. Now, I appreciate that it's a very short passage there. We don't see explication of the proximate cause test. I don't want to push it further than I can. But given, as your lordship noted earlier, the slimness of the bundle of authorities, we put this before the learned judge below as possibly a decision from which comfort could be taken.
you accept? I mean, they're just not dealing with the question of proximate cause.
Lord, it wasn't appealed, and no, it isn't dealt with in detail.
Well, all that I see in the second column on page 402, am I looking in the wrong place?
Lord, no.
All the special commissioners found was that the damage was caused by the explosion.
Exactly. But the test that they were applying in that case was a proximate cause test because they were looking at the marine risks insurance. I don't want to press the point further. It's not a direct authority in point, but it is a case where proximate causation has been found.
But nobody was, is this right? Had it been suggested at first instance that the cause of the explosion was, sorry, that the damage was not caused by the explosion? I'm not sure I follow.
There was no argument that appears to have been run, or certainly no argument succeeded, equivalent to Maloney and Friends' argument here. So Maloney and Friends says, well, passage of time means that the dropping of the bomb cannot have proximately caused the damage to Exeter's buildings. I'm simply highlighting to your lordships that on very similar facts, the court in that case found a causation. I don't put it more highly than that.
Yes, but the choice, as we see from page 400, right-hand column, paragraph 8, the case stated, they say the dredger sank because a discharge pump casing was fractured and water pumped into the hull. Fracture either due to back pressure or an explosion. The fall was improbable. In our view, the flat fracture was caused by an explosion in the pump. And then they go on to consider, well, what caused the explosion? And then they say it was the ammunition.
Lord, yes. I don't rely on the case any further than that analogy. If I can turn very briefly to the other authorities, and I'll purely do so by highlighting any points for your lordship's notebook that I particularly rely on. The first was the Brian Leighton case. And we can see from paragraph 34 that what the court was concerned with was to look behind the state of contamination and pollution to identify what had caused that. And that was the proximate cause. And as your lordships will anticipate, the analogy I draw here is one looks behind the bomb being discovered or being in the field ready to be discovered and looks at, well, what caused it to be there? And that is the proximate cause, that's the dropping of the bomb. My lord, I think we can move on from the other points in Brian Leighton because that was largely cited to counter an argument below that's not run on appeal.
Yes.
Because that was all concerned with the interpretation of the exclusion clause in that case.
Lord, yeah.
Because I mean, in fact, it's at the top of the page, isn't it? Lord Justice Popper setting out. There's the presumption, which you say applies here, full stop. But in that case, they were looking at whether it could be displaced as a matter of interpretation.
They were.
But that doesn't arise here because of what's agreed by, what is agreed that occasion by means.
Exactly. And it was also cited, obviously, in relation to the Wayne Tank rule, but there's no appeal in respect to that, so that doesn't arise. The next case to turn to was Reicher and Borwick. That obviously predates the Leyland case. The court is looking there not for the last in time cause, but is looking for the proximate cause, the real cause. I don't propose to take your lordship back through the passages, which my learned friend very fairly cited in full, but your lordship can see that at the top of page 552. Again, my learned friend took you to these passages. Even if a fresh cause arises, without which the original cause would not have led to the loss for which the claim is made, that does not mean that the original cause can't properly be viewed as the proximate cause. And we can see that in the judgment of Lord Justice Lopez, in particular the second paragraph on page 552, and then over to 553. Lord, I'm taking the authorities as quickly as I can. I don't think I need to take your lordships to any further points in Reicher and Borwick. Your lordships can see how I deal with them in my written argument. The same with FCA and Arch. I just want to note a couple of quick points, that the principles laid down there in relation to proximate cause, and I understand my learned friend to have accepted that in oral submissions, apply here. They're not somehow laid down in the context of, or limited to the context of, the facts that they were addressing there. They are the general test, not only that the judge was obliged to apply, and we say he did, but also the general test which forms part of the background against which the parties to this insurance contract are taken to have contracted. And with apologies for darting around, for your lordship's notebook, might I commend paragraphs 29 and 40 of Brian Leighton to your lordships in that context. But whether or not those signing up to the policy on behalf of Exeter really knew about the proximate cause test is not relevant. Parties are taken to have contracted against the background of that knowledge. Lord, I think I can move on from the authorities.
Can I just ask this? In relation to Arch, it's obviously a very useful condensation of those earlier authorities. Is there anything new in it as a matter of principle? One or two of the bits of language are potentially new, inevitable being one and agent of change being another. But you would say, as you said in your earlier submissions, you would say those are synonyms.
Indeed.
So other than potentially new synonyms, is there any, in your case, is there any new principle?
No new principle of application to this case. I'm being particularly cautious in case I'm in front of your lordship on another matter where I wish to find something new in Arch elsewhere. But
I think
for the purposes of this appeal, there is nothing in the test in Arch which is substantively new. There are new synonyms, but it is affirming the test that we see in Leyland and Reicher.
But I think I mean, it goes really back to what you were saying about the scope of the appeal, perhaps, but there is quite a useful passage, I think, at paragraphs 174 to 176 of Arch, when they're looking at concurrent clauses,
Absolutely.
and in particular 175, they say, in none of the cases could it be said that either cause, which was characterised as a proximate cause on its own, rendered the loss inevitable in the ordinary course of events. In each case, it was a combination of the two causes, which together made the loss inevitable. Neither would have caused the loss without the other.
Indeed. And we say, in answer to my Lord Justice Coulson's point, that is not new, but it is a helpful, clear restatement of existing law. And indeed, it was relied on below by both of us, because both of us urged the judge, as our alternative cases, to find that the dropping of the bomb and the controlled detonation were concurrent causes. And both of us relied on this passage as explicating what equal or nearly equal efficiency means, and a sense check that even if one cause on its own wouldn't have caused the loss, the court is concerned with how they're acting together, and that is sufficient for there to be concurrent causes. And that was Maloney Friend's submission below, from which he has not quite properly resiled, but also has not appealed the finding on that. Lord, the only two other cases that are not in this bundle because of the scope of agreement between us, but my Lord Justice Coulson indicated had been of interest in preparation, were the Mutual Life and Davis case and the Schneiderman case. But I think I can simply say that Maloney Friend dealt with them very fairly and indicated to the court why, in the light of them, he had abandoned a point that the damage needed to take place during the war. And again, the only point I want to raise is, again, this lack of a bright line does come in to the later stage, as I was submitting to my Lord Justice Snowden earlier. It does come in when one's not simply looking at a bright line, but looking at quite what the significance of the passage of time is under the common sense application. Because the parties have contracted against the background where the established law is the damage does not need to happen during the war. So, having taken your lordship through the authorities, I was proposing to turn to my fourth topic, which is grounds 1 to 3. But I'm conscious, and I was handed a note earlier, that we have live transcribers who would appreciate a break if your lordships were minded to grant them one at this point.
No, sorry. That's always my term of allowing transcribers at all, is there are no breaks.
In which case, my lord, I will turn to the fourth topic. Does Exeter make out its first basis of appeal that the judge, despite having correctly set out the law, nonetheless failed to apply it and instead applied a different legal test? Grounds 1 to 3. And I want to address this topic by making some general points and then simply commending to your lordships the written submissions in my skeleton argument. Ground 1 are dealt with in my skeleton at paragraphs 21 to 40. Ground 2 at 41 to 46. And ground 3 at 47 to 51. So the first general point, the This appeal is from a succinct, as my learned friend described it, admirably succinct, structured judgment. It not only follows a clear structure, but highlights that to the reader by the use of headings. It's accepted by Exeter, or I should change that, there was a slight query in oral submissions that the judge correctly set out the law, correctly set out the agreed facts, and correctly summarised the parties' submissions in relation to the application of the law to the facts. That's paragraphs 1 to 40 of the judgment. Grounds 1 to 3 of the appeal solely relate the short structured passage that immediately follows paragraphs 41 to 56. It's contended that the judge failed to apply the law that he had just correctly set out, and instead applied a different legal test that he never formulated. Now, stepping back from that, that is inherently unlikely in the context of this judgment, and that is a useful sense check on my learned friend's submissions. The second general point that I want to make is that, building on the submissions I made when looking at the agreed law, my learned friend agrees that the question of whether or not an act is proximately causative of the damage suffered is assessed at trial and is a backwards-looking test. It is not a forwards-looking test, identifying in some abstract sense whether a cause is proximately causative of damage yet to be suffered, and then looking to see whether that cause remains or peters out by the time of the damage. The proximate causation analysis is worked backwards. And a theme running through Exeter's submissions, which is why I take this as a general point, is that a lot happened between the dropping of the bomb, and viewed forwards, it wasn't inevitable that it will cause the damage that it did. But as I've already submitted, that's to look at things the wrong way round, and it's Exeter on appeal that is in fact misapplying the test and not the learned judge. The learned judge correctly looked at inevitability as a backwards exercise, the damage having happened. The third general point is another general theme of Exeter's submissions, is that the facts in this case are very different from the facts in Reicher and Leyland. They are, but that emphasis on the facts needs to be treated with caution. And the learned judge below rightly did and did not err and apply a different legal test. Leyland is not a case about what is a proximate cause when a ship suffers initial damage and then sinks shortly thereafter. It sets out a proximate cause test of general application, as Arch confirms at paragraph 166. So the facts may be illustrative of the application of the principle and are obviously the context in which the principle was expounded in those cases. But the judge here rightly did not reason by analogy to the facts in Reicher and Leyland, but by applying the general principle to the particular facts of this case, and he did not err in doing so.
But can I just ask you about his paragraph 42? He's presented with competing arguments. You saying, well, it's the bomb that is the proximate cause of the damage, and Exeter saying, no, it's not, it's the detonation of the bomb. Does he not get off on the wrong foot by, in effect, starting his discussion by saying, well, if I eliminate one of the possible contenders for the cause, I'm only left with the other one? Well, of course he is, if he eliminates one. But that sort of sets the tone for what follows, doesn't it?
My lord, I would suggest that the tone is in fact set by reading this section as a whole and looking at the headings that are used. What the judge is doing here in a very structured way is to say, okay, I've set out the test, now I'm going to apply it to the facts. Arch tells me that sometimes human intervention can be ignored, so what would happen if I ignored it? But I'm told by Arch not always to ignore it, so I'll then go on and say, well, what happens if I don't? Then passage of time, and then agency of change. So it's very structured.
Yeah.
My learned friend's criticism really amounts to the fact that this is a good structured judgment, and that rather than it being broken up, the judge sort of said, well, there's a lot I have to consider, and to consider it all in one. Instead, what the judge is doing is not reaching a conclusion at any stage, and we can see that because he's helpfully, for us as readers, at paragraph N, put the heading conclusion. What he's doing is breaking down the test that he's just correctly set out and looking at the various factors.
I mean, just out of interest, I mean, the point was made, I think, by Mr. Blina, that Arch doesn't in fact invite you, or there's no guidance in Arch that says ignore subsequent human actions. I mean, what paragraph 168 of Arch says is human actions are not generally regarded as negative in causal connection, but it doesn't sort of tell you to ignore them.
And the judge has correctly set that out when referring to the law earlier.
Yeah, but he seems to think that the general guidance in Arch was to leave out of account the act of detonation. I mean, that's the criticism.
It is, but it's the term leaving out. It doesn't mean that the judge is ignoring it. What he's saying is, if Arch tells us that human action would not normally negative it, then I approach it on that basis. That's how leave out is to be read. And then he goes on and says, well, Arch doesn't tell me I always have to do that, so I'll look at the human intervention anyway.
And he looks at human intervention from 44 onwards. What do you say about the point that's made about 45, that if there'd been no bomb, there would have been no explosion, which would appear to be a but-for test?
We don't read that as the substitution of a pure but-for test for the proximate cause test. That's simply part of the analysis, and of course your lordship will recall that in Arch, the but-for test is not irrelevant. It may, depending on the wording of a clause, be part of the analysis, but not the complete analysis. So the fact that the judge has expressed himself as he has in 45 doesn't indicate that he is not applying the proximate cause test and is purely applying a pure but-for test. It's one of the factors that he is entitled to look at.
Well, I mean, the key sentence from your perspective in 45 is the bomb provided both the explosive payload and the absolute need for the detonation.
Exactly. And
So he's saying there that the bomb and its payload made the detonation inevitable, if you want to use that word.
Lord, yes. And it's the payload of the bomb that causes the damage, which is one of the facts that Maloney Friend has agreed. It's the payload of the bomb, that vast amount of explosive, that has caused the damage to Exeter's buildings. It's not the fact that that damage has not been caused by the charge in the baldric alone.
But the absolute need for the detonation, you've got to be careful with that as well. There was no absolute need to blow the whole thing up.
And, my lord, I don't believe that the learned judge says that here.
No, but just to be clear, I mean, the absolute need was to do something about it to avoid a detonation, which they tried but failed. There was no absolute need to create the high level.
Indeed, and the learned judge doesn't say that.
Okay, but
He
just
says
so
there's a
we're clear when
need
we're looking at that.
Indeed, he says there's a need for detonation.
I mean, what causes the damage is the high level explosion. There was
Indeed.
no absolute need for a high level explosion. Everybody was trying to stop it, but it happened. What there was an absolute need to do was to do something about the bomb, because you couldn't just, once it had been disturbed or discovered, you couldn't just leave it there.
One couldn't, and nor in this case could it simply be moved from site, given that, and we can see that in the report, that would have required a 2-kilometre cordon round the vehicle.
But one of the troubles with this 45 is, as a matter of fact, there was no decision to detonate the bomb. The decision was to use baldricks on it with an attempt not to detonate it.
With respect, they are two different types of detonation, and that's why the learned judge is using that term here. We have a low order technique, an LOT detonation, or an HOT detonation, high order technique. So the contrast is, do you decide to detonate? Do you decide to leave it in situ and do nothing? Clearly not a realistic option. Do you decide to try and tackle the fuse? Not an option here because it's so severely rusted, as we can see. Or do you use ACE? Not an option here, as we've gone over. So the only option here was detonation. And detonation as a term covers both the low order technique and the high order technique.
I get that it covers both, but there is more than a hint in 45 that, is there more than a hint in 45 that the judge has not drawn those two, that distinction?
My lord, I don't believe so, and certainly there were.
He certainly doesn't join the dots, because he doesn't say there's an absolute need for a low order detonation, and the attempt to carry it out caused a high order detonation, but that was not inevitable, or there was certainly no absolute need for a high level detonation.
But he doesn't need to go that far.
Right.
What he's saying is there is an absolute need for a detonation. This bomb needs to be dealt with. It can't be left where it is, and there's no other way of dealing with it. So there is a need for a detonation. There are two methods that could be employed in detonation. One is a low order technique, one is a high order technique. As we've seen from the MOD report, as a matter of common sense, one goes for the LOT first to avoid damage if one can. But there's no criticism of the way the LOT was carried out. And there was no submission below by my learned friend that one needed to break down the detonation into its two phases, the attempted LOT and the fact that it didn't work, and the baldric triggered the high order technique.
That does rather suggest that it does look remarkably like a but-for test in paragraph 45.
Well, with respect, we don't read it like that. We read it that the judge is correctly applying the proximate cause test. And one element of that, as Arch indicates, is that one can look at but-for. It's not that but-for has suddenly become impermissible. It just is not the sole, it is not the complete test on proximate cause. And then we can see at L, goes on to look at passage of time.
Hang on, before we go to L, about 46. Can you make sense of 46 for me? Because I just struggle with 46 massively.
Lord, I was looking at that as your lordship raised it earlier. Is inevitable the wrong place in the sentence? Do we move inevitable around?
mean-
What the judge in 46 is doing here is responding to my learned friend's submission below, and indeed repeated on appeal, that you look at inevitability from the time of the dropping of the bomb. And is also looking at other counterfactuals that were raised. And the key sentence is not the first sentence, but is the sentence that it leads on to, which is the presence of the bomb that leads to both the need for the detonation and the inevitability of the damage. And at that point, the judge is looking at inevitability of damage.
But that's what I can't get. I can just about read the first sentence as meaning, if you assume the bomb exploded, if you assume that the bomb exploded when it landed and the buildings had been there, then obviously the proximate cause of the damage was the dropping of the bomb, because it would have been virtually simultaneous. And it would have been, that would have been the obviously correct answer. So I don't think the word inevitable at the end of the first sentence is really helpful. It probably just means correct. I would have been, but then the penultimate sentence, it is the presence of the bomb that leads to both the need for the detonation and the inevitability of the damage. That's given our previous discussion, that's not right, is it? Because, well, is it? Because if you have a need for a low order detonation, there's no inevitability of a high level detonation causing the damage. You just have a low order detonation.
Indeed, but one's looking at inevitability after we know that the LOT didn't work and that the high order technique unfortunately did take place and that caused the damage.
Well, we're told in the supplementary bundle, page 130, that the low order technique was chosen. Unfortunately, this caused the bomb to high order.
Exactly.
So
it's a
the
risk.
choice was the low order. It just had the unfortunate consequence.
The low order technique, and again, I'm trying not to give evidence, the low order technique is tried first because if you can have a successful low order technique, the payload of the bomb will not go off.
Well, I read this as meaning that the baldric in fact caused the high order detonation, even though it wasn't really meant to.
Yes, and that can happen, and that's why this sandbag construction
That can happen.
that can happen.
It's not inevitable.
But inevitability, my lord, is assessed not in a forwards looking at each
No, I'm
stage.
saying it's not inevitable at the time of the detonation, which is when the damage occurred. I think my lord's point is that that sentence leads to both the need for the detonation and the inevitability of the damage. On the face of it, isn't right.
But the inevitability, to pick up the point Lordship made, one's looking at inevitability not at the time of the detonation, but at the time of the damage. And they're not simultaneous because there's the low order technique.
But if you look at
then
it at the
high
time
order
of damage, you know that the damage has occurred. So of course it's inevitable, it's just occurred.
My lord, no, one's not looking at whether the damage was inevitable, but whether it was inevitable that the dropping of the bomb would cause it. That's where inevitability comes in.
Well,
It is part of the proximate cause test.
but even if you look at it at that stage, looking back, how can you say that the dropping of the bomb inevitably caused the damage? Because the bomb might, well, first of all, the bomb didn't go off at all. Secondly, their buildings weren't there at the time. Thirdly, they tried to use a technique, even when they did discover it, and they didn't set it off when they did discover it, they tried to use a technique which was designed not to cause the bomb to go off. And they thought they had a reasonable shot at that.
Exactly the same as in the shipping cases. When the torpedo hit, it wasn't inevitable that the ship would sink. It was taken to safe harbour, where it might have been saved. There were repair works done. A plug was put in. It so happened that the plug came out. But at the point the plug was put in, it wasn't inevitable that it would come out. wasn't inevitable that the attempted repairs would fail.
But the damage had been caused by that.
My lord, not the damage for which the claim under the insurance policy was made, only the initial damage.
Some of the damage.
Some of the damage,
Some of the
only
damage.
the initial damage.
Some of the damage was caused. I mean, I don't find either Reicher or Leyland surprising results. I think they're common sense, but they are to do with novus actus. They're to do with whether the second potential cause affected the analysis of causation. And this is an unusual case, I think, because there is only one cause of the damage, the controlled explosion. And so it's therefore a question of finding what's the proximate cause of that damage. But as a matter of fact, the explosion was the cause of the damage. So it's not like either Reicher or Leyland.
Lord, we don't say it's on all fours with either
No,
Reicher.
you've both been very fair about the limits of those cases.
But those cases, as we can see from Arch, and I don't want to keep repeating the point, my lord, if it's not helpful, but we can see from Arch that the proximate cause test set down in Leyland is not said to be one limited to cases where there is initial damage and then a novus actus.
And it's just a question of then applying those principles to a case where there is only one damage event.
My lord, indeed, and therefore if I take your lordship back to the sections of the judgment which are actually being appealed, your lordship can see in paragraphs 42 through to 51 that the judge is scrupulous to keep referring back to the general guidance set out in Arch.
Yes.
He makes reference at 48 to Leyland, a reference that Maloney Friend accepts is correct, that you shouldn't, when looking at proximate cause, be looking at the one nearest in time. But the judge here is
Shouldn't
applying...
necessarily be looking at the
No,
one nearest.
not necessarily. Indeed.
I mean, that's the second time you've made that submission. It's not, it may be the second in time. It may be the most recent. It depends on the analysis.
Absolutely. It's a question of, as my Lord Justice Snowden said earlier, causation is a net rather than a chain. One doesn't seize on the first, one doesn't seize on the last automatically. It's a question of assessing the actual causative impact of different matters within that net in order to identify which is proximate.
Yes.
So, my lord, that brings me to the last oral point that I wanted to make on grounds 1 to 3, which is that Maloney Friend said that the judge was in fact mistakenly analysing this as a novus actus case, and he failed to ask if the causative potency of the dropping of the bomb was sufficient. That is simply not right. He is applying the Arch test, in particular paragraph 168, that he has just referred to. My lord, those are the only submissions I want to make orally on grounds 1 to 3, and I would commend to your lordships the points that I put in writing my skeleton argument. I want to turn fifthly to ground 4. I'm not going to repeat the point I made in opening. I want to make a couple of short points in
If you're writing
addition.
your point in opening about ground 4, then that's the end of it in any event.
Exactly.
As I understood your submission, you say, how can it be said that no reasonable judge could have reached that finding when it was a finding that, for various reasons, both sides were asking him to make?
Exactly.
Have I got that right?
Exactly.
Yeah.
That is an end of everything. This is additional, if your lordship weren't with me on that. And I want to draw out the point that I made in footnote 19 of my skeleton argument, the last page, that my Lord Justice Coulson, in granting permission to appeal,
Oh, yes,
commented.
you ticked me off there. You ticked me off. You say it's not finely balanced. I may still disagree with that,
I
but
did.
anyway.
But if your lordship is right, then I would also seize on that to say, well, that's a very useful sense check on ground 4. Because if the arguments were finely balanced, then it really cannot be held that no reasonable judge could have come down in favour of Allianz. Indeed, Maloney Frank can only succeed on ground 4 if your lordship was wrong and that the arguments are not finely balanced, but so very, very clearly pointed towards the controlled detonation being the sole proximate cause that no reasonable judge could properly have found otherwise. Maloney Friend doesn't even make that submission. At paragraph 30 of his skeleton argument, he says the decision of the judge is wrong. He repeats that at paragraph 31 and again at paragraph 32. And again in oral submissions, he took ground 4 relatively swiftly, saying, well, I repeat my submissions under grounds 1 to 3, the decision was wrong. But that's not the test. He describes ground 4 at paragraph 30 of his skeleton argument as a catch-all. It isn't. It's not a way of sweeping up and simply repeating submissions about why the decision is wrong. He needs to satisfy this court that no reasonable judge could have found anything other than that the sole proximate cause was the controlled detonation. And he doesn't even go that far in his submissions.
Yes.
My lord, 6th topic, very briefly, summary and disposal. For all the reasons I've given, I submit that the appeal against the judge's finding that the dropping of the bomb was the proximate cause of the damage should fail. But, as I noted in opening, even if your lordships were with Maloney Friend on that matter, this appeal must fail because he has not appealed the judge's alternative finding that the dropping of the bomb was a concurrent proximate cause, nor can he do so because that was a finding he positively invited the judge at first instance to make.
That's presumably the transcript somewhere, is it? That invitation.
My lord, yes, that was his alternative case at trial. I can, if it would assist, while Maloney Friend is making his submissions in reply, I can go through the trial transcript to highlight for your
Well,
lordships.
you may not need to do it this afternoon, but I think we would like to see exactly where you say he invited the judge to make that finding.
As an alternative finding. My lord, if I can do it by the end of today, I will. I'm grateful.
Lords, I think I have 3 points only in
Yes.
response. The first point is going to be about the scope of the appeal, perhaps not surprisingly. The second point is about the agreement, the scope of the agreement in terms of the effect of the war. And the third point is about how you approach inevitability. Inevitability. So on the first point, if I can ask your lordships to first turn to the grounds of appeal, which are in the core bundle at tab 1, page 15. What your lordships will see there is that the grounds of appeal are plainly challenging the manner in which the judge concluded the finding of proximate cause. There is no limit on those grounds of appeal to say that it is only the finding that the bomb was the proximate cause. The grounds of appeal upon which this appeal was granted and the scope of it is set out is not at all limited in that way.
Well, the skeleton argument that I've got at any rate is the same skeleton that you use on the application for permission.
It is.
So I would expect to find in that skeleton a fleshing out of the grounds of appeal.
Yes?
So I think you're going to have to deal in head on with
Yes.
footnote 8.
Oh, I'm going to move.
Right.
And without wishing to spoil the suspense, it is and clearly is from the context a typographical error. It's as simple as that. And we can see it quite clearly. Because, firstly, as I say, the grounds of appeal themselves are not in any way limited. Secondly, when we look at the order which is sought, which we can see at page 8, the order that we are seeking is to set aside the declarations and to vary the order to issue a declaration that the loss and damage suffered does not fall within the scope of the war exclusion, properly construed. Now, given that we are not appealing the Wayne Tanks point, that order could only ever be achieved if we were challenging, as the grounds of appeal do, the full findings on proximate loss. When we then go to the skeleton, it is clear, if one doesn't just look at that one number, through the body of the skeleton, because I'm going to be held to my skeleton, I should be entitled to point to all of it, the scope of the point we are raising. So, for example, at 19C, it's clear from the final words that our case is plainly any causative potency of that initial event had ceased to have any effective impact, rather than saying we accept that it's a concurrent cause. The same point is in 19D over the page, where we end by saying the causative potency of a particular event peters out in some circumstances, but in this case, on these facts, it was clearly a long time before 2021. That's again making it clear. Then at paragraph 23, where we say that if the judge had properly considered agency of change, it would have been clear that the dropping of the bomb could not be the proximate cause, and goes on to say the only explanation for the change from that status quo was the discovery of the bomb and the steps taken to try and remove or detonate it with minimum damage. That was the agency of change. And at 24, on the final sentence again, talking about the change in the state of the bomb, which is the agency of change. And then I deal expressly with the concurrency point at paragraph 32, where I say, even contrary to the above, the dropping of the bomb remained a meaningful effective cause of the damage in 21. In order to succeed, Allianz would need to show that it was the dominant cause, or at the very least a cause of approximately equal efficacy as the controlled detonation. For all of the reasons set out above, of the two competing causes, it is clearly the controlled detonation that is the agency of change and the cause which is proximate in efficiency. So, save for the fact that there is a typographical error in footnote 8, which should read from 57, paragraph 57 to 72, and not from 52 to 72. If you take the skeleton as a whole and read it on the basis of the grounds of appeal...
Well, hang on, you can't just limit it. Wait a minute.
Sorry, Lord.
It's not just footnote 8, it's not a typo in footnote 8, it's also the text in paragraph 11, isn't it? It's the same point in paragraph 11, you expressly make the same point. I mean, you've got to take the two together. I mean, it's not just that you've made a typo in footnote 8, because you've actually written paragraph 11, setting out the two bits either side, and then specifically say, I'm not giving you a bit in between.
So, my lord, perhaps the error that has been made in that section is that when we look at the, get the judgment in front of me.
Yeah, I was just picking you up,
Yes.
sorry, on the basis you were just saying, just look at footnote 8.
Yeah.
It's a typo, it should have said the whole lot. And I was just pointing out that
Yeah.
actually that's ignoring the text of paragraph 11, to which it is a footnote.
It's clearly an error in that section, which is suggesting that our eyes have been focused on the main section of the judgment, and we are trying to say that have got the wrong paragraphs. We are trying to say that we are not appealing the Wayne Tanks point. And that is clear from the substance of the skeleton. And indeed, my learned friend was under no illusions as to the scope of the appeal, because this was a matter which did not appear in her skeleton argument. On the contrary, in her skeleton argument, and that's at tab 3, she says, at paragraph 5, having set out what is now agreed, she says there were only 2 issues finally in dispute at trial. And my learned friend says the first one is the matter of contractual interpretation as to whether the Wayne Tanks rule was ousted. And the second one was applying the agreed test for identifying the proximate cause to the agreed facts. Was the dropping of the bomb either the or a proximate cause? We then see at paragraph 7 that my learned friend says Exeter solely appeals the second point, which is the point which includes the dropping of the bomb being the or a proximate cause. At no point in that analysis does my learned friend say this point has not been appealed at all. In fact, she says exactly the opposite. And at paragraph 8, she goes on to say, the appeal will fail unless Exeter can persuade the court that the judge erred in finding that the dropping of the bomb was not only the sole cause, but even a component proximate cause. But doesn't say that that's not being appealed. It's open for, it's clearly being put that that's what the appeal is about. That's what the argument is actually about. And that's picked up again at the end of the skeleton at 52 onwards. Where again, my learned friend is talking about the fact that Wayne Tanks isn't now being appealed, and therefore the question is whether it was the or a proximate cause. Therefore, if Exeter fails to persuade the court that a reasonable judge could only have found the controlled detonation was the sole proximate cause, its appeal must fail. And over the page, ending with, for all the reasons set out in the judgment explored above, this was not a finding that no reasonable judge could reach given the agreed facts of law, nor were the findings that the dropping of the bomb was the or alternatively a current proximate cause of the damage. So what we say is we apologise unreservedly to the court for the confusion which we have created for the court in those sections that we looked at. But when one looks at the grounds of appeal themselves, when one looks at the order, which would make no sense if we weren't appealing the question of concurrent cause, and when looks at what my learned friend clearly understood the scope of the appeal to be, that it is plain what is the scope of the appeal.
Was there a 3-page response to the application for permission to appeal? Respondent.
I don't recall, my lord.
My lord, there was.
Yeah.
I don't believe that's in the bundles that your lordships have. I can, if necessary.
Well, either Mr. Polina's point will be perhaps reinforced if that 3-page didn't say this whole appeal is a waste of time because, or there might be something in it which actually he needs to address.
Well, my lord, of course,
if it's relevant. That's...
I do apologise. The skeleton that we've seen from my learned friend in the bundle, albeit the cross references to the bundles have been updated, came in July this year. And nowhere there does it tell us, or tell the court, nowhere here does it make the submission that my learned friend has made before yourselves today. Had that happened, we could have clarified it and dealt with it there. My lord, that's my first point.
On,
Yes,
on the substance,
yes,
leaving aside the procedural wrangle, if that's the right description, but on the substance, I think this is right, Mr. Pleener, isn't it? If you're right and the point was something which, as it were, is in play, the only paragraph of your skeleton that addresses it is 32. That's to say,
yes,
that's to say, if you're wrong, sorry,
yes,
if you're right about the proximate cause, Ms. Hitching has been clear throughout her skeleton, well, that's not enough, because if it's a proximate cause, then you still lose. And I think it's paragraph 32.
yes,
Because I think, certainly speaking for myself, that I did, when looking at the documents for the purposes of this appeal, it did seem to me to be a point, leaving aside this, the procedural point,
yes,
but on the substance, it was a point that Ms. Hitching made on more than one occasion. And in your skeleton, it is really limited to 32.
yes,
And in one sense, you just say, well, if you're right about the proximate cause, you're also right about a proximate cause.
yes. Because we would say, again, now turning to the substance, we would say, without wishing to, I think we're already conscious of the fact that the nature of setting out one's case here has the risk of simply repeating the phrase that I said at the start. All the reasons why we say this isn't a proximate cause are all the reasons why we say it isn't the proximate cause. My Lord, there's a secondary point to that, which is not the procedural wrangling point, but is whether this point is open to me on ground 4, because I had said, if I was wrong about our case, then it must at least be a concurrent case. So I don't accept that right. I can take your lordship to the way it's put at trial. I obviously haven't had as much time to research this point because it wasn't a point taken by my learned friend until now. But in the supplemental bundle at tab 3,
Yes.
at page 171, we see on internal page 93, where it starts the third point.
Yes.
The third point is if we are wrong about all of that, and that is the concurrent causes point, it's the mirror image of my learner friend's point where she says I only have to deal with concurrent causes. If I'm wrong, it's the same for me. If I'm wrong and the dropping of the bomb in 42 based on my learner friend's correspondence, if that is a proximate cause, but not the only proximate cause, then I have my concurrent causes point as a fail-safe, which was the Wayne Tank's point as a fail-safe. But it's plainly in the context of saying if we're wrong, our whole case is premised on the basis that neither of these are proximate causes. And I'm only addressing the fallback as if the judge tells me I'm wrong about that. Well, I'm already saying to the judge that that's not the correct answer. And that is the same way that we put it in our trial skeleton, where we say if we're wrong about proximate cause, it's plainly not the only proximate cause. So just because we say as an alternative, if the judge is against us on everything we're saying, then we have another answer, isn't to say, I would say, is not to accept that that is a reasonable conclusion to get to. We're simply saying if the judge comes to that conclusion contrary to all our submissions, then we have another possible answer. So I don't see that we should be poisoned.
This may be a bit academic, mightn't it? Because if you're wrong on grounds 1, 2, and 3, this court is unlikely to find ground 4.
Well, that
Isn't that right?
might not be for me to say, my lord, but
Well, I mean, usually the ground 4 type point is to do with findings of fact.
yes,
In this court, people say, well, they understand the limits of appealing matters of fact, but we say the judge got this so wrong that we say no reasonable judge could have reached that conclusion. That's obviously not this case.
Yes.
You've got your 3 separate points of law, all of which we've had submissions about, you're either right or wrong on those.
Yes.
But if you were wrong, it's a bit difficult to see how ground floor 4 gets off the ground.
Well, I suppose that what we had in mind, at least, was let's suppose that your lordships took the view, as my learned friend invites me to, that actually, despite the criticisms I've made about the way the judge approached it, he did in fact apply the right law. He did ask himself the right questions. Let's imagine that I'm wrong about all of those points. We would still say that even in that situation, your lordships are entitled to say, well, okay, if he did ask himself the right questions and apply the right law, he did still come to a decision that just could not possibly be right. And my learned friend says that we don't say in our submissions that I don't go beyond saying it's wrong. I don't say it was a conclusion that no reasonable judge could come to. But that's a little bit harsh when the actual ground of appeal with the head is saying, in any event, the judge reached a conclusion on proximate cause which was wrong and which no reasonable tribunal could reach based on the law and the facts of this case. So it might well be, my lord, that in reality, if I'm going to win, it's more likely on grounds 1, 2, and 3 than on 4. But we didn't want to leave the possibility that your lordships would be against 1 to 3 and still close that door.
Yeah.
My lord, that's my first point. The second point is just about the scope of the agreement about war, and I hope I can help with this. It is agreed that the damage itself does not have to have happened during the war. The event has to have happened during the war, which is said to be the proximate cause of the damage, but the actual damage doesn't have to have happened during the war. It's also agreed that there isn't a bright line cut-off, by which we mean, at least, it's not possible to say after 7 days, for example, nothing could have a proximate cause. But that is not to agree that, nor to preclude the court from concluding that the fact that this was an event from World War II, 80 years ago, is very relevant to the question of whether the proximate cause of this loss was occasioned by war. Because indeed that is the very nature of our complaint about it. So I hope that clarifies that. The final point on inevitability is just this, and I keep thinking that my learned friend and I agree on inevitability, and then I keep not being sure that we do. But let me try and at least set out what we understand it to mean, and I think this is largely agreed. We accept, and have always accepted, that you ask the question, standing here today, knowing what we now know. And you have to do that, because otherwise you've no idea whether there are other causes that might be proximate, nor, of course, you might not have known the truth about some of the extent of the original event. Taking Leyland as an example, what if they didn't know the size of the hole at the moment of the damage? So of course you don't simply put yourself at that moment and then look into the future in an abstract sense. But you are still saying, given what we know now, was it at the time of the event inevitable that this damage would occur?
The event, just for the transcript, the event there is the
Dropping of the bomb.
the war event,
Correct.
which is sought to be relied on to bring it into the exclusion.
Yes, exactly. My lord, that is in fact the point we were making at trial. And I'll just give your lordship the reference in case your lordships want to look at it, and then I'll just read the one line from it. It's back in the transcript at Supplemental Bundle tab 3, page 212, and it's at internal page 180. And it picks up with the paragraph that just says, we say that demonstrates two fundamental errors in how the insurers are approaching this and why it leads to the wrong answer. You do not ask.
I'm very sorry. Page
Sorry.
180,
It's 212 in the bundle,
212.
and then it's page 180 in the transcript. So it's the bottom right
Yeah,
box.
yeah. Sorry.
That's
Yeah. Two fundamental errors.
right, Lord. You do not ask what stops the bomb being proximate. We do not need to point to a moment in time where its causative potency had dwindled. That is to look at it from the wrong end of the telescope. You stand at the moment of the damage and ask, what is the proximate cause of this? What caused that change, that damage? The building was not damaged, and now it is. Why? So I simply make that because my learner friend repeatedly says that we're not doing that, but that was what we were doing all the way back into trial. Nothing's changed. So, my lord, subject to those 3 points that I wanted to bring up, unless there's something in particular that your lordships wanted to, I simply wanted to say that this is a matter for your lordships and my learned friend. I'm told that in the interim from when your lordships mentioned it this morning, that those behind me have found some photographs of the building and the site. I'm conscious that's not in evidence, so I'm reluctant to hand it up, or to make it available. I think it's only electronic. But I'm raising it in case, depending on what my learned
Unless
friend
there is an
thinks.
objection to your handing them in, I think it would be quite interesting, if nothing else, to see them.
Lord, with that expression of interest, I will make no objection, but if when your lordships are reflecting on this matter, something of significance
Yes.
appears to come from the photographs, I'd be grateful if we might have the opportunity both to see them ourselves and to make
I
short
wouldn't
submissions on that.
expect Mr. Pleener to hand them in at all without giving you the photographs in question.
We cannot see that they're of the slightest relevance, but if it's of interest,
Yes.
as certainly the BBC report was of general interest to me, then we have no objections.
Anything more, Peter?
No, thank you.
Right, thank you very much, Mr. Pleener.
Thank you.
Well, this has been a very interesting case on what I hope are unusual facts. So we will take time to consider our decision. You will get drafts in the usual way. That will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the drafts, you will be able to agree a formal order disposing of the appeal. If you can't agree a form of order, then please make short submissions in writing, and we will make the form of order that we consider to be appropriate.
Well, I'm grateful. I'm only getting to my feet to waving pieces of paper, not because I'm cheekily trying to make further submissions, but the promise I made that if I could, I'd give your lordship the reference to the transcript passages.
Yes.
My learned friend drew your lordship's attention to one passage, the key passage where his fallback argument was explored at some length in oral submissions, is in the supplemental bundle, page 199, and that's day 2, page 126, line 23, where it begins the second point. And one can in particular see the passage on page 128, where the judge says the choices are, the analysis really should be where there are more than one competing causes, and the question is, what is the proximate cause? Stage 1 is to discover if there is a single proximate cause. And Mr. Pleener says yes, and then Judge Bird says that is analysis at the analysis 1. At the moment, your argument is, I simply cannot conclude that. Mr. Pleener says yes. And then the judge goes on at the bottom of that page to deal with analysis number 2. If I'm with you on that, then that deals with analysis number 1. That is not an end of the matter, because the next question is, if I cannot say that one of those causes leads to the inevitable loss or was the agency of change, the next question for me is, are there equal or nearly equal causative potency in the end result? My only friend at the top of page 129 says yes. If I'm right on the first one, I don't need the second one. If I'm wrong on the first one, then I need to be able to say exactly that. And then we can see, and I won't read it all out now given time, but your lordships will be assisted by reading the rest of page 129, page 130, and to the top of 131, where Mr. Plena says, well, my lord, your lordship can certainly conclude if the bomb and the detonation are about equal potency, causative potency, then there would be concurrent causes. I agree with that. And that was his alternative case, and he wanted to run it because he thought he would get, because he was running the point that the clause, as a matter of interpretation, disapplied the Wayne Tank rule. He's not appealed that point, and in my submission, he's stuck with those submissions. And then the last reference is to his skeleton argument below, which your lordships can find in the supplemental bundle at page 242 to 243, Maloney Friends paragraphs 24 to 25. Which advance his fallback alternative case. That clearly is an alternative case, but it's an alternative case that he invited the judge to make, and his position was it was a perfectly reasonable alternative finding for the judge. Those are the references, and I hope that assists lordships.
Yes, thank you very much.
All right.